doing that.
I think that's fair. Fair with your boundaries. Yeah.
Yeah. Mhm.
Good morning, y'all.
Good morning. Zach is here.
Yes, ma'am. Ready to confer with a smile. Yeah.
Aw,
Do you have any patience in your pocket?
you better.
I always have patience in my pocket, Your Honor.
I like that. You know, if you put patience in your pocket and take it out as needed, it will be a great day.
Yes, ma'am. Absolutely.
All right, I'm going to call the docket. When I call the docket, you need to stand up and let me know you are here. If you don't stand up and let me know you're here, I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Pete Garcia, Devin Tyrell Strike. In custody, we have Jasmine Hunt, John Ramirez, Richard Alvarez. Thank you. Jeremy Duke. Carlos Arrojo, custody. John Perez, custody. Crystal Cherry, custody. Wilfredo Salinas, custody. Orlando Adino, custody. Nicholas Aguilar. Okay. All right. Jesus Trevino. In custody is Tracy Valdez, Andrew Orozco, Griselda Rosales. Thank you. Sarah Gutierrez. Michael Uguay. Arturo Lopez. Alberto Camacho. Mark Hernandez. Jason Wilson. Virginia Cerna, custody. Kelly Coter. Tony Torres. John Lyles. Andrew Arnett. Looks like, Deputy Lawyer, you're going to be busy today. Alexander Torres, custody. Stephen Estrada, custody. Jasmine Gallegos, Lucia Rowe.
Here you go, ma'am.
Lucia, all right. Rodolfo Aceves. Thank you. Kenan Brown, custody. Is there anyone whose name was not called? Yes, what's your name? All right, is there any reason you're not standing when you're addressing the court? First name? Ephraim. Last name Mahia?
Yes.
Do you know your case number or cause number? SID number? All right, we'll be with you. All right, these are the rules of the court, everyone. Do not approach the court if you have not conferred with the state and conferred with your client. If your client is in custody, yes, they need to be brought out for you to confer with them. If your client does not speak English or wishes to speak in a language other than English, you need to ask that the interpreter be brought down. Do not approach the bench while we are on the record. Do not talk behind the court reporter when we're on the record. If you have a client who is an inmate, just ask the deputies to move them down. Do not approach the coordinator or the clerk when we're on the record. And if your client is on probation or is here for a sentencing, please confer with the probation officer and do not turn your back to the probation officer because she is sitting there. And when she sits there and you turn your back to her, it is not a pretty sight. All the attorneys know that's where the inmates come from. Do not block that area. If you block their line of vision and something were to happen, I will do an affidavit saying that I told you not to block their line of vision. Does everyone understand? So today is Thursday, or as I like to call it, Friday's Eve. I know all of us wish we were retired. We are not, but the bright news is it is Friday's Eve. So make sure that you confer with kindness in your heart and a smile on your face. Everyone, please confer. Oh, no problem.
May I approach now, Your Honor?
Yes.
I'm here on Kelly Cotner. It's a bond issue.
Mhm.
And there was an issue about her having an ignition interlock.
Mhm.
And she doesn't have a car. I have her here and I have the affidavit of non-driving. I'd like to give it to the board.
All right.
May I?
If you'll give it to them, they'll hand it to me.
Okay. As I said, I had just recently been retained in this matter.
Mhm.
And otherwise, I would have let you know before that was issued that she is,
All right, Norma, is there a violation report on her?
there is.
All right, so that's what I need. All right, and you'll need to confer with the state. You'll need to confer with the state.
Bond matter?
Yes. Daniel, would you please confer with Mr. Sherman on this and look at the violation report? Oh, they'll come around and get it.
Um,
Thank you.
You have the violation report now?
Ms. Ferguson is pulling it.
Thank you.
All right.
It's supposed to have an ignition interruption. So I filed the affidavit. We came in earlier.
I remember talking out in the fourth floor by the window.
Right, yeah. So the judge wanted to put it on the docket today.
Okay. Oh, because of the violation report?
Right.
Okay.
So,
And Norma, we are breaking at 11:55 because at noon I'm supposed to do a tour of the juvenile facilities.
They didn't put it, what about screening?
Although
Right.
I'm not a juvenile judge, but we need to see where people are being housed.
Back to monitor.
Yes.
Morning, Your Honor.
Good morning. Mhm. Yeah. Yes. Okay, sure. All right, who is he? Excuse me, who is this person?
Sir, you have to.
Yes. All right, let me see that complete file. All right, Norman, can you call Austin Hagan and see if he can come back to court?
Have you called Dr. already, Your Honor?
Yes.
Okay.
Okay. And then Deputy Laura, if you can put Mr. Roa in the box.
Rob? Rob?
And then the other person we need to take up, if I could see the file on Mr. Aceves. Aceves. All the S's are confusing me.
Yeah, you're not.
All right, so Johnny, on this case, if you'll speak with Miss Abrams when she comes back. I think there may be some miscommunication about whether or not he's supposed to be seeing a therapist or not seeing a therapist. So if you could talk to her about that, and then we'll see where we are. Oh, she's here. Hello. Okay, so I was talking to him about his client and that there may be some confusion.
Oh, Mr. Aceves?
Yes. So it was from my understanding that, from my understanding, he was supposed to be attending treatment,
My understanding,
either through a psychologist, a therapist, some type of mental health treatment.
okay, unless I don't remember correctly, which is very possible.
Yeah.
My understanding was he was supposed to get evaluated and then he was supposed to be told what to do. I never got any news after the evaluation. So I don't know where he stands.
I believe when he was here the last time, he was evaluated or he was seeing someone privately.
First row,
Okay.
you just got
Is
here.
that correct or?
I don't remember, to be honest with you, because I moved on to the next.
Right,
cases.
understood.
Mhm.
Well, let me ask you all this. Has he ever been evaluated?
I have to pull up his file.
All right, let's see if he's been evaluated first. Yes, with you all. If he hasn't been evaluated with you all, then let's see if we can get him evaluated with the MIC unit and see what their recommendations are.
Okay.
And then if their recommendations are he needs to see a doctor, then can you arrange that?
Yes, ma'am.
All right, so let's see that first.
But I think you've already ordered that he get evaluated by Mickey.
Let me
Okay.
pull up
Yeah.
the file. okay?
All right,
Okay,
Sure.
we're looking.
all right,
Thank
thanks.
you. How's mom, by the way?
Oh, mom is doing great.
Good.
Yeah,
How was you spend New Year's over there too?
yes.
Good.
And you know, my family, our goal for the new year is to survive, to see the new year, because so much happens.
Really,
Right.
yeah.
And so we all survived to see the new year, but she's doing great.
That's good.
How is your wife doing?
She's doing good. I gave her a $100,000 ring for Christmas and she made me return it. Look, so she's not too mentally healthy.
Let me see.
I thought it was a perfect ring.
Yeah, almost there. She's there.
You're so funny.
Yeah, but it's on my right, so.
I don't know.
Yeah, but okay, I know. What about the artist? Yeah. Yeah, I think that's on the. I don't know, I'm gonna March. You might mention in March, so that's okay. Every day, man. Cool, that's good then. I got
My knowledge does.
Nate,
We'll see.
first row, sir. Ethan Hunt.
Yeah, Jasmine.
Oh, let me see if I have it. Hold on, just a second. Sometimes they'll send it to me.
No. No.
Adriana, on this one, can you make sure there's a affirmative
I do want to make sure that he's not.
I emailed you that. And I said, please do not send it to Jeff. But I do not want to send it to Jeff. If not, I couldn't have it turned on.
She wants to see me. She has to get permission.
Is it for you?
First row. Sit down the first row.
Go and come back.
And, you know,
May we approach your honor?
Yes.
Judge, it appears that he was evaluated through the access program.
Mhm.
And they did not feel that he met the criteria for any further treatment.
Okay.
There was a supplemental report sent to the court, and one of the option was for us just to monitor, and then you would speak with him in regards to his treatment on his last compliance hearing.
Okay.
If any treatment was gonna be ordered, there was no modifications to his conditions at the time.
Okay.
The only modification was in regards to his GPS.
Okay.
So,
So with regards to his GPS, have there been any violations or anything?
not that's notated, Judge.
Okay. All right, Mr. Aceves. Aceves.
He's never had a violation since day one.
Okay.
I can get you a copy of that back in a minute. if you'd like.
Oh, no, no problem. You're an officer of court and I know you, Johnny. I trust you. All right, how's everything going?
Pretty good, man.
All right, so how are you spending your time? What are you doing?
I spend it at home with my family and try to into for a job and all that.
All right, how's the job search going?
Pretty well. I'm still waiting for an interview for the construction business, and I don't know if I'm gonna get a call this week or the next week, but maybe if I be able.
All right, just 1 second. Excuse me, if you all can't whisper, then you're all gonna have to confer outside.
Daniel,
If I will be able, try to look for another job, see if they do not contract me on.
All right, and so are you doing school or looking into school or anything of that nature?
Now, right now, I'm looking just for a job right now.
Any type of trade school or
Also,
trade school or anything of that nature? What are you planning on doing with your future?
for a GED.
All right. So you said GED?
Mhm.
All right, have you started working towards that?
So,
Say yes, ma'am, or no, ma'am, when she asks you a question.
no, not right now, man.
All right, so it's probably best if he starts trying to get his GED if he doesn't have it.
Yes, ma'am, that's what you're working on, correct? Trying to get your GED?
Mm-hmm.
Okay.
All right, so his GPS, what is the status of that? Is he on tracking or does he have scheduled?
I
set
think
time?
he still has a full house GPS for the first 3 or 6 months.
Mhm.
And then after that, we're gonna reevaluate, I believe, if I remember correctly.
All right, it's been 3 months.
Yes, ma'am. But I think it was 3 months, but I'm not sure. I don't want to lie to the court.
No. Because I think it's time for him not to be on full GPS.
Your Honor, in December, the conditions were modified for partial GPS,
Mhm.
and there have not been any violation.
All right, and so then we said partial, I believe, I guess I probably said partial for work or to look for work.
Employment and mandated classes only.
All right. So are you okay with loosening that a little bit to giving him some extra time or no?
You're right.
Yes, I do see that, we have been in communication with him in regards to, certain job fairs and so forth. He's in compliance with all of his field visits, he's reporting on time.
So I think,
Judge, if we put him on tracking, he can go out and look for other jobs. He can stop at job sites and things.
well,
like
I think what I'll start with, because now it's just partial. I'll start with him being allowed to do things in certain hours. So if it's not work related, or if it's not for classes, I'll allow him to be out and about till 6 p.m.
Okay.
That means that you'll have to be at home at 6 p.m. Now, if you're at work and your work schedule takes you beyond 6 p.m., that's fine. So we'll start with that. And then the next time, if there are no issues, then we'll start with tracking only and then hopefully move towards removal.
So from what time to what time? I know from till 6 p.m., but what?
We'll
time?
do it Monday. Through what date? Do you want Monday through Friday or Monday through Sunday?
Judge, we don't have any, I would say Monday through Saturday.
All right. Monday through Saturday, we'll do 7 a.m. to 6 p.m.
6 a.m.,
7 a.m. to 6
6
p.m.
a.m. to 6 p.m.
Okay, you want 6 a.m. to 6, okay.
Yes, Judge.
She's
That
fighting for
way,
you.
just because, just in case he gets a job to where he has to, you know,
All right, so your GPS now will be 6 a.m. to 6 p.m. That's whether you're looking for employment or whether you have a class or not. If you want to go to the park, then you can do that. So that's from 6 a.m. to 6 p.m. If there is something where you have employment and that employment takes you outside of that window or a class takes you outside of that window, let probation know.
Okay, okay. Yeah, I will notify them if it takes longer than 6 a.m., 6 p.m., sorry.
All right. So then what we'll do is we will see how that goes and we'll come back in 3 months. And in 3 months, it'll probably, if there are no issues, then it'll probably be tracking only. And then 3 more months, if there are no issues and nobody objects, it'll probably be removal.
Good. Just yesterday, it just happened that I got a call from an old client.
Mhm.
He owns a house framing business.
Mhm.
And he had some traffic tickets, so I went to pick up the money, pay the tickets. I'm gonna call him and see if he can use it.
Okay, awesome.
Okay.
Thank you. Johnny, you're so awesome.
Well,
I've known you forever. I've known you when I was a defense attorney and a prosecutor. You're just awesome.
well, thank you. So are you. That's why I love coming here.
Oh, thank you. So Norma, on this case, if you can give me a date to come back in 3 months,
What?
April 4th or April 11th.
May I look at my phone?
Sure. Or if you want a date other than that, just let us know.
Your Honor, while he's looking at his calendar, as far as the mental health treatment is concerned, are we okay just to monitor at this point? And if
Yes.
anything arises, let the court
Yes.
know?
We'll monitor. And if there are some issues that you're having, be sure to let your attorney know and let probation know, because we can't help you if we don't know.
Okay, ma'am.
And the last thing you want to happen is something that happened, and then you come back to this court and saying that you didn't tell anybody,
Mhm.
because in this court, I believe that communication is key. When I place people on probation, I want them to be successful. So you have no excuse. And if the probation officer, who is your probation officer, is not addressing some issue you have, you can always call your attorney, or either you can always come to court.
Right, will do, ma'am.
All right, what,
April the 4th, Your Honor.
all right, Norma, we're gonna call this back on April 4th.
First one, after you finish.
So, este consumo como para ayuda psicológica, estoy en eso.
Mhm. You okay?
También the anger management, porque
Are you taking anger management?
no, es en hold. Así como,
Okay,
I see.
perdón.
all right, anything else that's needed?
He's wondering about something, let me find it on the page.
No, perdón.
Something about anger management, but I don't remember anything about anger management.
Let me see.
Yes.
I don't have anything listed on the docket sheet that he's supposed to do anger management
What is the
classes.
anger management?
It was on hold until something happens or something like that.
Oh, so it's in abeyance? All right. Bashan, he has some concerns about his conditions.
No sé si lo han
I don't have him down for anger management, but he thinks the paperwork he's reading says that maybe it's in abeyance or something. If you could review that.
Yeah, I don't remember anything.
It's right here.
Yeah, have anger management held in abeyance.
All right, so yes,
That
you
was
don't have
on
to,
his original conditions.
all right, so you don't have to do that.
Not yet, not, you don't have to do that. That's why it says that, okay?
And I don't know if Johnny would like a copy of that.
This-
Yes.
Okay.
All right, is there anything else?
No, you on.
All right, thank you. Good luck
Yeah,
to
make a
you.
copy
Thank
for
you for the good work.
Thank you, Your
I'll
Honor.
put one in the
For her.
board.
Okay, thank you. Thank you, Your
All
Honor.
right, thank you. Have a good one.
Yes, ma'am, you too.
All right, Melvin, this is John. Kelly Cottner. If you'll come forward.
We conferred, Judge.
All right. All right, so she's providing an affidavit of non-driving. So what type of device do you all want her on?
Scram, Judge.
Okay,
Now, Judge, she's currently has an ankle monitor GPS tracking. And she's under house arrest. And rather than have two monitors, we're asking that it be partial, some sort of partial house arrest so that she can take care of business and including visiting with me. Because it's time, there are time constraints. And I don't want to have to deal with that.
I'm not the one who put her on GPS. State, are you ready to address GPS issues?
Yes, Judge. In talking with Mr. Sharman, I guess the state has a number of questions. Mr. Sharman's related that she has a number of business interests, both in this county and out of county. I just wanted to maybe see if we can get more information on that before making a decision to switch to partial. And I kind of understand it's more to do with land and other regulation in other counties. Is that correct?
All right,
Yes.
then what I can tell you is I'm not going to address the issue with GPS as far as removal. But of course, with GPS, she's allowed to visit her attorney. And I will place in this order, a defendant allowed to visit her attorney for legal matters. And then any other issues with GPS, you all need to file a motion and I will hear it.
I think we've already filed a motion to modify.
I think we did.
Yeah, and
Okay, I don't have that. If you want to go to back and have them pull it, State, are you ready to have that heard?
Yes, Your Honor.
All right, so if somebody will pull that motion for me, I will hear it.
okay. Get the file and bring it to you.
Yes, well, there is no file, but there should be a motion.
Okay.
Sarah Gutierrez. Hello, so where are we on, hello,
Hi.
hi, so where are we on the eval?
It's going on, I think, the 17th of this month.
And
Okay,
it's Dr. Steve, Judge, and He's gonna be via Zoom.
okay. And who is it with?
Dr. Smith,
Okay. All right, Norma, if you can give me a reset date for 45 days.
yes, ma'am. I can do the 22nd. February 22nd.
All right, we'll come back on February 22nd. By then, hopefully I'll have an update on the evaluation. Make sure you make that evaluation, okay?
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you.
All right, thank you for dressing appropriately for court.
Of course, thank you. I have a seat, they'll take it to you. Thank you.
You're welcome. Is the attorney here on Lucio Roa?
Judge,
Yes. Norma, can you call Hagee? Austin Hagee?
Okay.
All right, Tony Torres. Good morning. Counsel, you're on the other side. All right, this is your third violation report. So it says that your device has not been calibrated.
Judge, I spoke to my client about that. I will tell you, he has some memory issues. He has some mental health issues that are going on. According to him, he's never been informed that he needs to calibrate it each month. I've explained that to him today.
Okay,
also
I know
told-
he's been informed that he needs to calibrate it.
I've told him he needs to start writing things down if he's not remembering what his pretrial officer or anybody else is telling him. As far as I know, he's been testing negative for all drugs, any alcohol. He's been on random UAs the whole time. He tells me he's not drinking. So it is his third violation. The two previous violations were a delay in getting the device installed. He does not have a vehicle, so we had to appear before you to get an in-home device authorized. So he hasn't been tested positive for alcohol, Judge. I have told him there are rules that he needs to abide by, and if he can't remember them, he needs to write them down. But we're set for a plea hearing next week. I anticipate getting it disposed off of your docket. I'm asking you to keep this.
Can't we get it disposed now? State is here, file is here.
I haven't reviewed the videos with him yet, Judge.
All right, if you all want to review, State, do you have the videos down here?
I can download it for a judge.
I have them in my possession, Judge. I'd like to review them in my office. That was the plan, was to meet with him this weekend, come back on Tuesday, let him decide if he wants to plea or go to trial on the case. I have two other settings in two different district courts today, and I have a misdemeanor case. So if you can give us until Tuesday, he's told me every single time, I'm not drinking, I'll test negative for anything. I think it's just a matter of logistics, not
All right.
violating his bond conditions.
So I understand what you're saying, but a lot of people say that they'll test negative and they're not drinking. But then they get tested and it turns out they're drinking. State, do you have anything to say with regards to this violation?
Well, Judge, this is the third one. I've conferred with defense and we thought we'd leave it in your hands. I know that it's set for next week. We have made an offer. I just, I know he wants to review it. We were thinking maybe the scram might be appropriate, but I don't know if he's gonna even get that installed before it's set in next week, so. This is the third violation, Judge.
All right, I'm gonna have you all come back at 1:30 and you can watch videos with him over the break or either before. So I'm gonna make my ruling on this at 1:30. So everyone comes back at 1:30.
Thank you, Judge.
Okay. Okay, sure. Norma, this case is coming back at 1:30.
Yes, ma'am. This goes to her.
Yes.
All right. Diane, are you ready to go on the record?
Yes. He was
Court is
pointing out-
calling.
Are you talking to me?
Yeah, are you all ready?
Judge, just one more.
All right, sure.
Bringing something out.
Okay.
When you come back, I'll put the file in there. Okay. So are you open to screen? As soon as you come back, I will.
Jasmine Gallegos. Devon Strike,
Here, Your Honor.
Jeremy Duke, Jeremy Joseph Duke,
Not here.
Jesus Trevino, Michael Ugui, John Lyles, Mark Hernandez, Jason Wilson, Andrew Arnett, Jasmine Gallegos. Oh, no, I'm gonna rule on this today. Let's see if he's available to do this and see if he can call his client. And have him come in.
And
You want me to approach?
Yes.
I called a Freeman friend of mine,
Mhm.
doesn't need anybody, but I called another friend and he's gonna hire him.
Oh, awesome. Jenny, you're so awesome.
It's the biggest cabinet making company in San Antonio.
Oh, that is so great.
So I'm gonna take him to interview.
Wow. Oh.
And he said, if you recommend him, I'm gonna hire him. So I'm gonna take him, I can't today, but
Mhm.
tomorrow I'll take him over there and he's got a job.
Oh, that is so awesome.
Okay.
Thank you, Johnny.
No.
Saving people one person at a time. I like it.
I believe in this young man.
I do too.
Yeah, I know you do, I can tell.
Yeah.
And he's doing good. I mean, he's just said the wrong thing.
Yeah.
So anyway, I'll let you know. about
Oh,
the
hey,
job.
awesome.
Okay, bye-bye.
Thank you. And Michael, on that case, I know they're asking for GPS, correct? So I'm gonna end up granting that. I don't know if you're going to. You know, and then if we're able to have a hearing on your client and I figure out what's going on and it needs not be there, of course, I'll recall that.
Sure.
But I don't know if you want to confer with the state over that.
The only thing is, time wise is just, I've got
Oh, no,
I
I
got my thing
understand.
with you this morning and then I'm
Mhm.
going to 144, so.
Okay.
set it for next week.
No, I mean, I'm going to have to rule on that now.
We confer, babe. Babe. We confer.
Thank you, Mikey.
Thank you.
Thank you, babe.
Judge, may I approach another matter?
Yes.
With our bond reduction, the state had a offense report. I don't know if you want to read that beforehand
Yes.
instead of us standing around. Yeah. Thank you. No, I have a copy on it.
This is a criminal history.
Okay, in which case is this?
This is for the.
Virginia Serna.
All right, is Virginia Cerner, can we have her brought out?
Yeah, we'll get her.
And I'll read this.
Oh, yeah. John Ferry? Yeah.
We approve it.
Yes.
Yeah, that's.
The state wanted to introduce some police reports, and I kind of object to that because you're the trial judge. And so what I'd like to do is maybe have this assigned to the magistrate.
I'm available to hear bond matters. So this is what the court is gonna do. Ms. Kotner, if you can come forward, please. So, I'm gonna continue on GPS. I'm gonna order the scram and the removal of the, ignition interlock requirement. And I've notated on the sheet that you provided an affidavit of non-driving. You have 2 days to comply with Scram. Counsel, if there is some issue with them not being able to set up an appointment with her with Scram, let the court know. But for now, it's 2 days to comply. Of course, you'll be allowed to meet with your attorney. And with regards to the GPS, if y'all want the court to hear it today, I'll hear it today. If you don't want me to hear it today, then pick a date for me to hear it. All right?
Well, the same issue is going to be here.
Yeah, so the question is, do y'all want me to hear it today or not? If y'all don't want me to hear it, then we won't hear it today. If y'all want me to want this GPS heard, then I will hear it today. Otherwise, talk to the coordinator and she'll put it on the docket for this court for another day. So
All right,
just let the
you
court
will
know.
Not send us to a magistrate.
No, everybody's here. I'm here. State's here. We can hear it.
I understand that, but I object to the evidence that they want.
All right. So, Ms. Ferguson,
Yes, ma'am.
Ms. Cotner,
Yes,
Yes,
can you set this for a bond hearing in this court with regards to GPS
ma'am.
and give it someday next week? Y'all will be ready next week?
I'll be in trial next week.
All right, just pick a date with Ms. Ferguson and she will give you the date and we'll hear it.
Okay.
All right?
Thank you, Judge.
Unless,
You're welcome. Thank you for dressing appropriately for court.
do you want to keep that, or do you want me to?
Yeah, if I can have it.
And Norma, on this, we need to make sure that pretrial services have it because otherwise they'll continue to say they don't have her affidavit.
Judge, is she excused now?
Well, Norma's going to give you all a date to sign a form.
Okay. Just.
No, that's good. Oh, yeah, it is NIMAC number 740266.
We're picking the jury on Monday and then
Monday's a holiday.
Tuesday. And then, I don't know how long it's going to take, probably.
No, this is the first. I just wanted to.
The 25th.
And counsel, you put in your motion for her to have the scram on or about the January 15th. And so the court's order for the 2 days is within the time frame you requested.
If I have an appointment for her within 2 days and they can't get to it, can I just present that to the court?
Oh, yes, but your appointment should not interfere with them putting the scram on her.
The appointment won't interfere with it?
No, your request for her to meet with you should
No,
not
no.
interfere with her scram.
What I'm saying is that if, say, she wants to get a scram, they say, well, we can't get to you for 5 days.
Oh, yeah, just let the court know.
That's what I'm saying.
Sure.
Okay, I don't want to get in trouble because she doesn't have it in 2 days if they don't.
No. And I'm sure they'll have it though. Wilfredo Salinas.
What date are you putting?
Salinas? Let us get it.
There's something for her to sign.
Hello. All right, they were just bringing you out. Have you had a chance to speak with your attorney? All right, so Mr. Salinas? Okay. They'll put him in the box. Deputy Laura, they're not ready on Salinas. Hi, you're here for Salinas?
Yes, yes.
This is his attorney, and so we'll put it in the box. Okay. Norma? Thanks. I thought she was back. All right, no problem. Norma. All right, thank you. Yes, hi. All right, just give me 1 second. All right, yes. Yes, yay. Mhm. No, he's on the docket, but I told them not to bring him over. Just so we can figure out a date. Okay. Can I see the file?
He's actually just on the 16th, it has the 16th on it.
Mhm.
So I would have to go with that and pull it.
All right, yeah, it's just for her to be here, not her client, because I know he's not gonna be over the illness. But if you want to take that up now, we can.
So on the 6th. Oh,
No, we can take it up now if you want to, because it's just to get a date.
that's fine.
Okay, sure.
I'll do that. 2022.
Mr. DeLeon, whenever you're ready on your client, Virginia Serta.
All right, Judge, we're ready to go whenever you are.
Okay,
Judge, do I have a couple minutes on that one?
sure. And could I see the file on Virginia Serta?
Did you check? No, she can, she's not full file.
And Mr. DeLeon, this is a motion for bond reduction, correct?
It is, Your Honor.
All right, could I see the motion for the bond reduction, Ms. Ferguson, if y'all can pull that? No.
So, yes, ma'am.
Okay, thanks.
You can look it up by the way.
And Mr. DeLeon, I'm assuming it's going to be a jury trial for the aggravated assault?
Yes, Your Honor. In fact, we want to like to, after the hearing, make sure we expedite that.
Yes.
And Judge, I'm sorry to interrupt. Is the motions that you want, is it on the NICA cases?
Yes.
Okay. Just making sure. I'm gonna pull them right now.
That's correct. You want the bond reductions on the CM cases, correct?
And to reinstate bond or set a bond on the original ag assault.
All right. Well, unless the state has witnesses for the aggravated assault, there's going to be a bond set, since the rules of evidence will apply in that case. Deputy Laura, where's Mr. Lucio?
Oh, come back.
Oh, okay.
Down, Judge.
I know you do. I'm like, I'm testing my memory because I didn't see him over there.
We need the states and his attorney's not here.
Yeah. All right, Salinas. Wilfredo Salinas.
Salinas.
Who is the prosecutor on Wilfredo Salinas?
So, I got it.
All right. So where are we on discovery?
So, this is the first setting, the state was gonna ask for time to reach out to the plaintiff.
All right, and Mr. Salinas, are you a citizen?
No.
All right, does he need an immigration attorney appointed?
Not at this point in time, I don't believe, Your Honor.
All right, so are you gonna handle his immigration issues?
Well, we're just handling the criminal side of it right now. Is he,
No, he's gonna need an immigration attorney.
okay, okay.
So are you all retained?
Yes, we are. If the
All right.
court deems it necessary, they can go ahead and start the process.
Well, no, are you all gonna pay for him to have an immigration attorney?
No, we're doing the criminal side of it. We're just doing the criminal.
No, I mean, well, the reason why I asked is because legally,
Mhm.
immigration issues have to be addressed with him. Because he cannot enter a plea without someone telling him the consequences.
Oh, yeah, yes, I'm certified as an immigration law attorney as well, Your Honor.
Okay, all right.
However, I don't think he's gonna be pleading right now.
No. I don't want anything to hold up this case. I don't
Okay.
want us to have a jury trial and we can't go because the immigration issues have not been addressed. So you're gonna address the immigration issues as it relates to this case with him?
Yes, ma'am.
All right, thank you. All right, Ms. Ferguson,
Yes, ma'am.
on Wilfredo Salinas, if I can have a 30-day reset, please.
Your Honor, I have a quick request as well.
Yes.
I didn't get information as to whether or not an amount is bail has been set
Mhm.
for Mr. Salinas. Is there any way we can get that amount set here, or do we have to set a separate hearing?
Oh, no, you just file a motion and we'll hear it if there is some bond issues. So you
Okay.
just file the motion and we'll hear it.
Okay, so I don't know if the amount set now will be considered to be an excessive amount.
Oh, if you all think that he can't pay that, then if you want to file a motion for a reduction of bond, the court will hear it.
Okay, all right.
Okay,
No
thank you.
problem.
All right, we'll come back on February 12th. And yes, and Norma, Mr. Salinas is not a US citizen, but his counsel is telling me that he will handle the immigration issues as it relates to this case.
Is that at 9?
Yes.
All right, is there anything else?
Go, Your Honor.
All right, thank you.
Maybe, excuse Your Honor.
Yes.
Okay.
Do you know, is there an ICE hold on him?
Van a hacer una moción, va a hacer una petición para que me reduzcan la fianza.
Counsel, do you know if there's an ICE hold on him?
I'm not certain whether or not there is one. I can check into it, Your Honor, and I can send it to the court coordinator.
All right, yes.
Thank you.
All right, thank you. Have a great day.
Okay, you too, Your Honor. Thank you.
May I return? Yes. Your order. Sure. And whenever you all are ready on Cerner, just let me know.
Thank you so much.
Yes.
Thank you.
Yes, there's not.
Thanks, Your Honor.
All right, thank you. All right, state. Daniel. On Wilfredo Salinas, there's an ICE hold. So this case is gonna have to move very quickly, otherwise they're gonna take him.
Yes, sir.
That solves the problem.
Yeah, some people say that solves the problem, but then some people say it just complicates things.
Is it like this swallowing the spider to get the fly?
There's no motion.
Okay, all right, thank you. All right, are you all ready?
I think we're ready, Judge.
Okay. Who is the prosecutor on Virginia Serna?
It's the judge.
Mr. Wilkins.
All right, so Mr. DeLeon, your motions are lost in the system somewhere.
Joy.
So are you all okay with proceeding without his
Yes.
physical motions?
Yes, ma'am. I'm gonna give you the.
Sure.
Judge, can I approach this as the conditions of bond that have already been put in place?
We're gonna go on the record. Court is calling CM 114217, 114220, and 114222, State of Texas versus Virginia Serna. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Serna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at 15,000. That occurred early in 2023. She, in late October of 2023, picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay, so today we're gonna.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're gonna be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at 75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're gonna be asking for a bond of 10,000 each on the aggravated robberies, given the circumstances.
All right, and what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at 15,000, but we will go with whatever the court wishes to do.
All right. And state, are you prepared to proceed?
Yes, ma'am, we're ready.
Any witnesses? State or defense?
I mean,
None, Your Honor. I do have, I'd like to give the court a packet. I can do it one or two ways, either, and I've shown this to Mr. Wilkins. Series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures are.
All right, any objections to defense exhibit number 1?
no objection, Your Honor.
All right, then the court will set exception to evidence defendants exhibit number 1.
And if I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is Christopher Cooper, who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants and their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she
Right.
was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks. And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be two complainants with someone with a gun, but there's no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, but there's no face, but it appeared there's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm, but again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client. She has identified the 3 complainants, that being Jonathan, Joseph, and Christopher being the ones in the photos. And I'll also point out to the court that these photos taken from social media were my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to a La Quinta to see a just under 2-year-old stepsister that was born that Mr. Christopher Cooper has never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity if she's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness essentially of this allegation, we're asking that bonds be set of $10,000 on the aggravated robberies so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These 3 charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that the bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right, state.
Yes, Your Honor, we are asking that you double the bond on the aggravated assault deadly weapon from 15,000 to 30,000. And we're asking that on the aggravated robberies, that you keep the bonds at 75,000 each. We're also asking that you, she has these conditions of bond, the special conditions of bond, Judge, that I take to the court. We're asking that you keep the GPS with full house arrest in place, no contact with complainant witnesses in the aggravated robberies, Jonathan Vidales, Joseph Berrientos, and Christopher Cooper, a prohibition on possessing firearms, And Judge, I've previously tendered to the court the police report. I didn't mark those. I have stickers here if you'd like.
If you mark those as states exhibits 1, 2, and 3. And defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then states exhibits 1, 2, and 3 are admitted, and of course, defendants exhibit number 1 is admitted. And you can tender those to the court reporter. I've reviewed those.
Okay, this one. So just
And
briefly,
I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
just real briefly, the argument, in the police report, these are very serious allegations. We're asking that the bond be set at this high, or kept at this high number in order to protect the community. The code says that you can set reasonable conditions of bond. We think under the facts alleged in this police report, these are reasonable conditions, this amount, as well as for full house arrest GPS. And if you were inclined to grant a lower amount of bond, we would still ask for the other conditions, the full house arrest GPS, Judge. But I reviewed those pictures, and I think some of the questions that maybe the court had too. You know, this is a picture. I don't really know what this is depicting. This could be an airsoft gun. This could be a real gun. These guys could be engaging in blunting, or this could be tobacco. A couple of these guys are juveniles, so they have guns in these pictures that are undated, I think. We don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not in any of the police reports. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest GPS, Your Honor.
And lastly, Judge, if I may,
Yes.
what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm, but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. So I don't know how he would see if there are guns or not in there.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
A few more things. No, I'm just kidding.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815 and CM number 114217. The court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. And cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna?
Yes, ma'am.
There's to be no contact with Ruben Cerna. All right, is there anything else?
Nothing, Your Honor. Thank you.
All right, Ms.
Oh.
Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, Judge.
All right. So that means it'll probably be 2 days. The earliest date you have. All right, we'll come back with jury trial on February 6th. If you're still in custody, you will be brought over in trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor, we thank the court.
All right, and do you know if your client will be going, if she were found guilty, do you know if she'd be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right, on Eric Lopez. All right, thank you. Yes,
Good morning.
good morning. Norma, on this case, when do you want to bring it back for jury trial? Daniel, this is yours. Yes,
So the court's aware, in speaking to one of the detectives involved in the case, she is currently pregnant. She did say, I think she was due in March, so if there's any time in between now and March that we could set this on.
All right, Norma, we'll need some time before March.
And-
Yes.
And then my understanding is that she's going on maternity leave for, I think, six to 8 weeks.
All right, when will that be?
I believe that's gonna be starting in March. It really is just kind of a rolling date because I think,
Yes.
because it just coincides with.
All right, so we're gonna come back on February 6th for jury trial.
Thank you, Judge.
Thank you, Judge.
All right, you're welcome. So you don't need to be here on the 16th.
Okay, I appreciate it. Thank you.
Pete Garcia? Oh, do you need a break? All right, just give us 1 second. I'm sorry, just a brief break. I'm sorry. It is CM 114217, CM 114220, and CM 114222. And then the other cause number is 2023 CR 5815. Sure. Andrew Orozco. Andrew Orozco.
He's out here, Your Honor.
All right, come forward, please. Well, so where are we on this case?
So this case, Your Honor, was originally assigned to Mitchell Russell.
Yes.
So the court, Norma's gonna appoint me on this case, Judge, because he has pending aggravated assault with deadly weapon case
Okay.
amongst other cases. I conferred with Daniel on this matter. The state wants to reset so we can move forward on the higher offense level cases.
All right, so, okay.
He asked for it.
All right, so can you give me a month reset? Is that enough time for everyone?
Yes. I'll just say.
Okay, all right.
I can do February 12th.
All right, we'll be back.
Defense counsel will be out. Remember, I don't come back until we try that case with Kathy Compton.
Yes.
I leave on the 8th, we'll be back the 18th. Then we start the trial, I think, on the 20th.
Which case are you, because are you on Eric Lopez with her or no?
No.
Angel.
Angel, okay.
Remember, the one that starts that Tuesday.
So let's put it on the same date as that.
Tuesday,
Yes.
That
February
works.
20th.
All right, February 20th.
Yes, Judge, thank you.
All right, is there anything else?
No.
All right, thank you.
Thank you, Judge.
You're welcome.
I have.
John Anthony Ramirez. Who's the attorney for John Anthony Ramirez? Dinah, you ready? Are you all ready to proceed on the motion to revoke?
Yes, Your Honor.
Court is calling 2000. Please do not talk behind the court reporter. We're on the record. If y'all will remove it to this end. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Michael, can you all move it to that end?
Yes.
All right. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Could I have parties announced for the record for the state?
State of Texas.
Defense?
Renee Munoz on behalf of John Ramirez.
Are you Mr. Ramirez? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same John Anthony Ramirez who was placed on deferred adjudication in 2016 CR 6340 for the offense of aggravated assault with a deadly weapon on April 10th, 2017 for a period of 5 years and extended for a total of 3 years? All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant, John Anthony Ramirez, did then and there fail to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, we have already confirmed with probation. It's for the defendant to, report twice a month, for 3 months virtually or in person. Monthly UAs, for the defendant to continue treatment, with the Center for Healthcare Services and to comply with his medications. And that would alter and amend, and we would ask that he did not.
All right, probation.
Your Honor, we did confer that agreement. I'm sorry, the agreement, it's not, that is the agreement.
All right, so here's the court's issue. He's been here before me previously for not reporting. So how is this going to solve the issue? And I'm taking in consideration his mental health issues. So how is this solving the issue?
Yes, Your Honor, at first glance, I can see the court's concern. I spoke with my client and he did state that he was and is currently receiving services with the Center for Healthcare Services, Judge. He has been prescribing to them. I am receipts of a document from Jennifer Munoz, his case manager.
Mhm.
I can tender it to the court.
Yes,
if the court
please.
doesn't have an issue with that. He's been under their care for the last 18 months, Your Honor. and been-
All right, you all need to whisper in the box. If you can't whisper in the box, then you can't talk in the box.
He's been reporting with them for the last 18 months and has been consistent with his appointments with them, Judge. He started off with pills, oral medications, but now he's on the injection. He takes once a month and he's now currently stabilized. I believe the issue was a little miscommunication with probation. I know that probation wanted him to try to get help at Palo Alto. My client states that he went to Palo Alto to get help and they said, we can't double up on your care. You're already seeing the Center for Healthcare Services. My client has stated that he can't afford the UAs and the probation officer essentially said, figure it out. And we are figuring out, Judge. His family's going to help contribute to that UA. So that's not going to be an issue. And I told clients that, no excuses in terms of not missing probation. If he needs to take the bus, he needs to take the earliest bus possible. So even if he misses a bus, he's on time. If he's there and they're saying they can't meet with him, to document that, to take a picture, he was there, email me, email the court. Hey, I'm here. The probation officer is not able to meet with me at this time. He's wanting to reschedule, but he has been making his appointments regularly with Center, Judge, and he has been doing well with them. So it seems like, he has a lot going on, but I'm telling him that he needs to make good on his requirements to the court and probation, that they need to meet with him, they need to see him. But his sister did furnish me that document from Center from Healthcare that he is receiving treatment, Judge. And I think he does seem stabilized to me. He does seem like he's wanting the treatment and he's already set up with the center. So we're respectfully asking the court for him to allow that. I did talk with him about the proposition before the court with meeting with probation. He has no issue going there down in person. He's going to take the bus. He's going to have family members take them. He's going to establish a better communication with the probation officer. I think has a year left after all the extensions when it's all said and done to expire in 2025 in April, Judge. So I'm encouraging him to give this last push. He's been on probation for quite a while. I think this case originated in 2016. So he has not picked up any new number ones. He has not demonstrated any violent behavior. He's demonstrated that he does need mental health services and he is, he is taking measures to help himself in that regard, Judge. So we're asking the court respectfully.
All right, and probation, I'm assuming that you all will have access to his compliance with Center for Healthcare Services?
Your Honor, we'll ask for a release of information.
Oh, you have the release?
Yes, Judge, I filled it
Thank
out
you.
just in case we need the records from Center.
All right. All right, so I don't think it would be appropriate for him to have to report more often than he's currently reporting, because it seems to me the issue is his mental health. So if there's no objections, what I'll do is I'll deny the motion, alter the main conditions, and he's continue with mental health care with Center for Healthcare Services. He's you to make sure that you report monthly. You understand?
Yes, ma'am.
And you are to provide a release so that the probation will be able to see how your treatment is going for Center for Healthcare Services. The court will note for the record that that release has been signed. Is that correct, counsel?
Yes, Your Honor. We have executed that and
All right, is there anything else?
nothing further, Judge. We greatly appreciate the court's time and consideration.
Thank you, ma'am.
All right, Mr. Ramirez, we're off the record. If there is an issue, you can always come to court and let the court know what the issue is, and we'll make sure that you're on track.
Okay.
You understand?
Yes, ma'am, I understand.
All right, good luck to you.
Thank you, ma'am, very much, ma'am.
All right, you're welcome. Philip Diller,
Morning, Your Honor.
good morning.
I just needed to approach the court. I have just conferring with the Assistant District Attorney. I had previously spoken this morning to Anna.
Mhm.
We are set on the 16th for a jury trial.
Yes.
And we were set earlier in January and the court set it for the 16th.
Yes.
Well, back in October, had a felony case in Comal County that was set for trial on the exact same day, January 16th.
Mhm.
But they make you come the Tuesday before, which was a couple days ago.
Yes.
And then I received an email from them
Mhm.
that I have to be there on Tuesday by 9:45, ready to go to trial on that case. And so I had that setting prior. And that case was set prior to when the setting was changed to the 16th. So I'm just looking for court's guidance. Do I go there? Do I tell them I can't go there?
Well, is that case in Comal County a felony?
Yes, it's a felony drug case.
All right, and how long has that case been set?
It's,
I mean, how old is that case? Because we've been trying to get a jury trial done on this.
you're right, Judge. You're right. I believe that the case, certainly the offense date for the 187th case is many, many years before this guy's case.
So what we will do is this will be set in this court on January 16th. And if you need us to, we'll call Comal County and let them know that you're here. So we will put you under the umbrella of the 187th and it will be fine.
Okay.
Yeah.
That's fair.
Sure. All right.
Thank you, Your Honor.
You're welcome.
No, have a great day.
You too. All right, are we ready on Pete Garcia? Oh, it's coming back on the 16th. It's still scheduled for trial, but we'll probably need to call Comal County on the 16th and let them know he's in trial here.
Right in the middle.
Hello, good morning. All right, I believe this is family violence.
Over here now, right?
Yes. And Mr. DeLeon, you need to go to another court for your jury trial?
Eventually, but I have another matter.
All right, whenever you're ready, let us know. Court is calling 2022 CR 6930, State of Texas versus Pete Garcia. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense?
Daniel De La Garza for the defendant.
And are you Mr. Garcia? You entered a plea on December 5th to count 1 of guilty. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. The state is opposing your application. They're taking in consideration 2023 CR 8852 and 2023 CR 8851. And there is to be restitution, if any, to the complainants in each of those cause numbers. No contact with the complainant and Chapter 62 compliance. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No, Your Honor.
No, Your Honor.
All right, are there any witnesses?
No, Your Honor.
None from the state, Your Honor.
All right, state you are opposed.
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Your Honor, the state would just like to begin when looking at the PSI, this individual had cases out of, I believe it's Manatee County, Florida, put on probation for a drug offense, 28 grams to 150 kilograms.
Just 1 second, I'm sorry. Probation?
Yes, Judge.
On this case, I don't have the PSI report in the email.
Judge, my apologies.
That's okay. Ah. Thank you. Just give me 2 minutes.
Absolutely.
Oh, okay, thanks. All right, you may proceed.
Thank you, Your Honor. This individual was placed on probation on 2 different occasions out of Manatee County, Florida, once in 2006 for 28 grams to 150 kilograms of cocaine charge. Also 2007 out of Manatee County, Florida for use of investment proceeds from racketeering. That's 2 separate instances of probation outside of the state of Texas. Within the state, within Barrett County, there was this individual was transferred to TDC and sentenced in 2019 with tampering of a government record. Also 2019, unauthorized use of a motor propelled vehicle. Again, sentenced, transferred to TDC on both of those. The victim in the credit card abuse case said in the PSI quote, "I'm not okay with probation. I want him to do time. I'm sure he will do it to someone else. I don't think probation is the solution. He will do it again. He will do this to someone else." The victim in the fraudulent use or possession of an ID case said, quote, "I'm absolutely not okay with him applying for probation. I just want him to go to jail forever if possible. He is an egregious violator of the law." So that's with respect to those 2 cases, Your Honor, that were taken into consideration. In the instant case, the indecency with a child by contact, as is mentioned in the STIPs, a short 2 or 3 sentences from the report. Juvenile Jalissa Leone told her mother that Pete Garcia fondled her breast and nipples on 10 separate occasions. She stated the incidents occurred when she was 11 years old, while Pete Garcia resided at the residence. Juvenile Jalissa Leone did tell one of the interviewers that it never went further than that, but that Pete Garcia told her, quote, "Don't tell your mother," when the incidents occurred. Your Honor, in the PSI, this would be victim number 3, Your Honor, again, with respect to the indecency. When questioned, that victim said, if you just give the state one quick moment, Your Honor. Again, victim Jalissa Leone said, quote, "I want him to take some accountability. I don't want probation for him. I suffer from really bad PTSD now because of this incident. I get scared to go to sleep because I have really bad dreams. I get scared to be alone with certain people because I never know what could happen." And Your Honor, I think the word there that of course sticks out to me from the victim in our case, the indecency, the incident case, I should say, is that accountability. And to kind of in summation, if you will, Your Honor, the final point is when the defendant, speaking to the accountability, when the defendant was questioned about why he feels he should be granted probation, he told them, quote, "I need to continue with the life I was living." Well, the life he was living, Your Honor, caused all of this harm in Barrett County alone, and of course, criminal offenses stretching back over 15 years. When asked, the defendant said, quote, "I don't want to talk about this right now. I wasn't consuming alcohol or drugs on the date of offense." A lack of accountability and wanting to go back to the life he lived, as if somehow not being under the influence of drugs makes any of this conduct okay, Your Honor. The state respectfully believes that this individual is not qualified or suited, again, under the eyes of the state for probation.
All right, defense.
Just briefly, Your Honor, he definitely does take accountability. He does take responsibility for what happened, and he'll be happy to tell you that if you'd like to ask him. But the point
Does he
is that
want to testify?
you want to tell the judge that you're sorry.
Here's the thing, before you begin, if you want to testify, you're going to be placed under oath. and the state will have a chance to cross-examine. So do you wish to testify? All right, can you raise your right hand? Excuse me, person in the black jacket. The person in the black jacket, they need to be excused from the courtroom. They're talking to someone in the box. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor, I do.
All right, you can lower your name, sorry, lower your hand and state your name for the record.
Pete Garcia.
All right, Mr. Garcia, just one moment. Mr. DeLeon,
Yes, Your Honor.
do you, let me know if you need to go for your jury trial?
I don't really want to go that bad, but I appreciate it.
All right, just let me know. All right, we may continue. All right, defense?
Yes, Your Honor. Well, hold on, I'm gonna ask you some questions, all right? So first off, you know that you've pleaded guilty to the indecency case, right?
Yes.
And then you've taken responsibility also for the credit card theft and the fraud cases, right? For lack of a better term.
Yes, come 100%. I just want to pay back the restitution.
I'm sorry, you need to speak up.
I just want to give a chance to pay back the restitution, Your Honor. You know, the last 3 years of my life, for once, I have a good paying job. I just signed a 30-year mortgage 8 months ago. My life is finally on track, and you know, this incident happened in 2016, 2017. 7 years later, it came up, and I do take full responsibility of all my actions. I do.
So let me ask you, when you say all your actions, are you talking about the case that you have pleaded guilty to, the sex offense, for lack of a better term?
Yes.
And you're talking about the cases that the judge will take into consideration? You take responsibility for all that, right?
Yes.
Now, let me ask you questions. Now, tell the judge, when the prosecutor says, go back to the lifestyle or whatever, what did you mean by that?
What I meant was, in the last 3 years, Your Honor, my life has been, me and my spouse, I have been on track. I go out for a month, I come home for a week. I've been doing that for 3 years. I finally, like I said, Your Honor, the life is what I meant was me getting my life back on track, finally living a normal life.
Now, let me ask you, who is your spouse?
Jasmine Manion,
Is she here today?
Yes.
I'm gonna point out for Your Honor. Sure. Right there in the Under Armour shirt, waving her hand. Okay, and then if you were granted probation, is that where you would go back to live?
Yes.
Okay, and let me ask you, are there minor children in that house?
None.
And you have your own children, right?
Yes, they're grown.
What do you mean by grown? How old's the youngest?
21.
Okay, and do they have children?
Yes, my son does.
Okay, now if the court will order you to have no contact with minor children, is that something that you'll abide by, first off?
Yes.
Then second of all, you're gonna have all kinds of conditions that you need to abide by, such as the sex offender counseling, maintaining employment, reporting to probation. Are you gonna do all that stuff?
100% complete, yes.
And then where are you gonna go back to work?
At Halliburton.
What's that?
It's a oil and gas company.
What do you do there?
I'm a CDL driver. I deliver frac sand.
And if your CDL license is suspended or you lose that, where would you go work at that point? Let's just say.
It's a family member that works there. I would be working as a laborer.
And then now the judge is going to can give you up to 8 years in prison or deferred adjudication for up to 10 years. What are you asking to happen?
Judge, I'm asking for the 10 years and just to give me that chance to pay back this restitution. And I just, for one time, have a normal life. I accept everything that I did. I just want to move forward. I finally have it, and I feel like everything's gonna get taken away, but I do accept full responsibility, man. I do. I just want that chance to pay back, give them what they're asking for, the restitution, and just move on with my life.
Pass the witness, sir.
Right, state.
Just a couple of questions, Your Honor. Were you aware that when the complainant first outcried, the reason the outcry happened when it did is because she was having frequent and violent sexual dreams? Were you aware of that?
No, I have had no contact with them in 8 years.
And if she hadn't had such violent dreams, there's reason to believe that she wouldn't have outcried. If she wouldn't have, would you have done something to take accountability for your actions, confess or do other actions or take other actions to take responsibility for the double-digit number of times that there was the touching of the breast with your hands?
I'm sorry, I don't understand.
And I apologize, to put it simply, if she had never outcried, would you have found a way to take accountability for your actions?
If there was something said, then of course, 100%. Would, I do take accountability for my actions, and like I said, it's been almost 8 years. I have not heard anything until recently. So, of course, yes, I 100%.
No further questions, Your Honor.
All right. So I have a question for both parties with regards to the restitution amounts. One complainant says the restitution amount is 0. Mejia is saying their restitution amount is $15,000, but that $15,000, they're saying that's the money they borrowed, but that the bank reimbursed them.
That was my understanding.
So it appears that the money has been reimbursed. So I understand that there's costs because they borrowed $15,000, but then the bank reimbursed $15,000. Now I can understand maybe he's responsible for the interest on the $15,000, but the court doesn't have the interest amount for that. But, and if I'm wrong in my legal conclusion to this, I don't think he's responsible for the entirety of the $15,000 if the bank, and it appears from what I'm reading, the bank has given him back the $15,000.
Yes, Your Honor. I would agree with that, absolutely.
So I don't have a restitution amount for that.
Yes, Your Honor, I believe that is correct. I see exactly what the court is saying, and yeah, I don't believe there would be any restitution remedy available.
Okay. All right. This is what the court is going to do. The court will deny your application. Does anybody want to speak to the cap? The court is going to find you guilty. Anyone want to speak to the cap of 8 years?
Nothing from the state, Your Honor.
Well, just Your Honor, we would ask that he, based upon the fact that he has taken responsibility and that he has, done his best to make amends for what he's done, that we ask that you hit somewhere below the cap. And I would leave that up to the court's wise judgment, but I would ask somewhere below the 8 years.
All right. All right, Mr. Garcia, I want to let you know that I read the entirety of the PSI report. I read the police report. And I've seen the ages of the complainant, the age of the complainant in this case. That's an issue for the court. You understand? All right, the court will find you guilty, sentence you to a $1,500 fine, time and money to run concurrent, take in consideration 2023 CR 8852, 2023 CR 8851. There's to be Chapter 62 registration, no contact with the complainant and either of the cause numbers. The court will sentence you to 8 years in the prison, give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, true.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor.
All right. So off the record, I understand that people have regrets about things that they've done in their past. And sometimes we hope that our past won't come back and bite us, right? Because you moved on with your life. I understand it as you're working. I know that that job you had was a great job. I know you have the 30-year mortgage, but when offenses and crimes happen, you have to answer for those. And at some point, what we've done catches up with us. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
And I'll need those dismissals. Who's here on Stephen Estrada?
Judge, I hate to do this, I don't want to do this, but he was trying to talk to me for a second. I was dealing with another case. Would you flip me one behind so I can hear what he said?
Sure.
He may not want to talk to me, but he said it's.
Okay. John Ray Pettis.
Judge, that's an MTR ready, I believe.
Judge, we're not quite ready yet, sorry, still looking at it.
All right. John Thomas Lyles.
Yeah, don't present on that.
Judge, I'm Mr. Stroud, I'm ready after the others.
Thank you.
I don't believe Mr. Lyles has appeared, Judge, if the court would recall, he's rather mentally challenged. The court suggested that we reach out to mental health coordinator. I have, but I haven't had any contact since we were here a couple of weeks ago.
All right, is he on,
On bond, but not on, I don't.
is he on a surety bond or a PR bond?
Surety bond, I believe.
It's John Lyles. And do you have any contact information for him?
He wouldn't give me anything other than a friend of his mother's, so,
All right.
and he is homeless, Judge.
All right.
Doesn't-
Court is calling 2023 CR 9074, State of Texas versus John Thomas Lyles. Can I have parties approach and announce for the record for the state?
Hank Wilkins for the state judge.
Defense?
Tony Adonis on behalf of Mr. Lyles.
All right, this hearing was scheduled at 10:40, I'm sorry, at 9 a.m. It is now 10:46 a.m. The defendant has not appeared. Counsel, do you have any idea where your client is?
I do not, Judge. I know he is homeless, but he did sign the reset notice to be here today.
All right, and this is a commercial bond state?
Your Honor, we're asking for a bond forfeiture this morning.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider. You may want to try calling the bondsman and maybe they have contact information for him.
I'll do that. Thank you.
All right. Miguel Ugui.
Michael Ugu, Judge.
Ah, Michael, thank you. All right, today is the plea deadline date.
Judge, we received a plea offer today that may or may not change depending on the prosecutor's contact with the complainants over this week.
Judge, we're arranging for a time to speak with the complainant. I made an offer, but it's one that still, we spoke with the complainant briefly through our victim advocate, and they stated this is what I'm offering is within what they would want. I'm just gonna talk to them to see if there's anything that we can do.
All right, Ms. Ferguson, on this case, if you'll call it back for January 18th.
Thank you, Judge.
Thank you.
All right, once you sign the reset form, you're excused.
That'll be our plea deadline, Judge.
Yes.
Thank you.
And counsel, your client was late.
Judge, he stopped me as I walked in and told me that he was outside on the bench. He didn't notice the people coming in. But he knows to be inside.
Okay, all right, thank you. Are y'all ready on John Pettis or still conferring? All right. Stephen Estrada.
Judge, Mr. Estrada was kind enough to let me know that somehow they said he was exposed to COVID, so I got him a mask. That's why he's wearing a mask. I don't know if it's true or not, but anyway, that's why.
All right, so we were scheduled for jury trial. Where are we?
Judge, you made an offer. I've thoroughly discussed the offer with Mr. Estrada. I've explained the consequences of not taking the offer and that the court will not take any agreement. It will just be an open plea in court. I passed on the offer and I'll be real blunt. I've given him ojos that if he gets a lot higher, it's on him, not me, and I'm not going to feel guilty. He said that he wants a trial, so I'm passing it on to the court to get it.
All right, Ms. Ferguson, I need a jury trial date for this. It's criminal trial division. I need it as early as possible. All right, you're coming back for jury trial on February 6th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll need to plead open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and do a clothing exchange. If there's an issue with the clothing exchange, let the court know.
Judge, I appreciate it. Thank you for letting me come in today rather than Tuesday. And I'm still gonna bet with you on the fact that they're gonna cancel court that.
You think they're going to cancel the court on that date?
It's not that I would, but I've just, you notice certain things like the sun rising in the east and setting on the west. and After a while, you notice patterns.
Okay.
Your Honor, may I say something, Mom?
Sure.
I just want to see if I'll be able to dismissal counsel. I've been incarcerated going on 3 years and I still to see yet the discovery pack on any racing arrest.
Oh, you want to see the evidence? State, can we put him in the box? Counsel, can you let him see the evidence? And if you want another attorney for your jury trial, they need to be ready for trial on February 6th. You understand?
No.
And Judge, just be clear, I don't care one way or another, but if you are gonna put someone else on the case, please let me know so I won't.
Oh, no, he's going to have if he wants another attorney, you'll have to hire that attorney.
What
And that
is it,
attorney
Rob?
needs to be excused. That attorney needs to be ready for jury trial on February 6th. And state, if you'll let him and counsel, if you'll stay so he can see the state trial. Sure. Arturo Lopez.
We can have a few more minutes, and we just change something on that.
Okay,
Judge, we're ready on ours.
all right. Thank you. John Ray Perez. Oh, and state, if you all want to speak with Mr. Contrail about his client who was here the other day.
Oh, yeah. There's a warrant for his arrest now.
Yes.
He didn't come back yesterday because I was told he did.
Oh, no, I think the person he was with, they came back and stood in the hallway. So he may make an appearance. Court is calling 2022 CR 7826A, State of Texas versus John Ray Perez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael DeLeon for Mr. Pettis.
And are you Mr. Perez? All right, everyone, we're on the record, so I'm going to ask that you please whisper. If you cannot whisper, then do not talk while we're on the record. All right, did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision? With your attorney, did you understand it? All right, you're going to have to make sure you speak up.
Yes, Your Honor.
All right. Are you the same John Ray Perez who was placed on deferred adjudication in 2022 CR 7826A for the offense of burglary of a building with intent to commit theft on January 10th, 2023 for a term of 2 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 1 on or about the 8th day of November 2023 in Bexar County, Texas. The defendant, John Ray Perez, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
And Your Honor, we waived the other violations alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
We're asking that you deny the motion and continue the defendant on community supervision. We would like to alter and amend the conditions for SATIF. That's going to run concurrent with the new number 1, concurrent with County Court 2 case 72109-7.
All right. And with regards to the county court cause number, is that case still open?
It is, Your Honor, because it's enhanceable. I would like the defendant's going to go down and plead directly after this sentencing to that cause.
All right. And who's the attorney on that case that's in misdemeanor court?
Feel like it's me now. So
You're just coming forward solving problems.
I'll take care of it, Judge.
All right. And Mr. Perez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
John Ray Pettis,
All right, so what's your drug issue?
Maryland.
All right, we're doing more than SATA for marijuana, are we not?
That's the only drug I just.
I'm sorry, Judge, I didn't hear you.
All right, Mr. Pettis said the only problem he has is marijuana and nothing else.
Your Honor, we don't have any. We don't have any drug tests to confirm that there
Has-
was a violation to his outpatient program.
Have you done anything on probation other than
I went
not
to-
report, pick up a new case and not doing your drug testing?
I went to my classes.
What classes?
The drug classes. I think you
Okay,
said.
obviously, they're not working, right?
Right.
So you're just telling me you'd rather go to 2 years to the state jail facility and then come out and use your marijuana?
No, Your Honor.
Then why are you using marijuana? Because I know people think marijuana is not a big deal. But I tell you what, in Texas, it is. And you can't smoke marijuana or use marijuana in brownies or cookies or whatever while you're on probation. You can't even drink alcohol while you're on probation in Texas. So would you like, if you want, I will grant this motion and I will send you to the state jail facility. You will be done. And if you choose to smoke marijuana, that's on you. If you get caught smoking marijuana, you're going to get arrested. That's on you. So if you want treatment, I will give you treatment. But if this is just, I'm doing my best right now to stay out of custody as quickly as possible, but you're still going to use, then now's your time to make the call because you know yourself better than your attorney does. And is there a family member here for you?
No, ma'am.
All right. So you know yourself better than I do and the attorneys do. So if you want, I will deny the motion of alternate amend conditions and send you to SATA. Or I will revoke you and I will revoke you and sentence you to 180 days.
Your Honor, if I may,
Yes.
Mr. Pettis and I had a conversation. I think he wants to avoid having a felony conviction on his record. He doesn't have any other felony convictions before, so that was the reason why when probation recommended SATF, we're like, okay, we'll do it.
Okay.
I had the same reaction when I heard marijuana as well. I'm like, but unless that's different, Mr. Pettis, unless you want to do 180 days and just have a conviction on your record and do 106 months in state jail facility.
180 days.
Yeah,
It's day for day.
day for day, but it's a conviction on your record.
And let me just tell you what's going to end up happening. When I do that, if that's what you want, when you are released, you're going to immediately go back to doing what you previously been doing. And one or two things going to happen. Either you're going to pick up another evading case or something else is going to happen. And you're going to be right back in somebody's felony court or misdemeanor court or whatever. And your problems will still be there because when you stop running, your problem is still there.
No, I'd rather take the help.
Okay. And is there something you wish to say?
Oh, yes, Your Honor. I believe after speaking with probation, his probation will need to be extended 6 months to accommodate the SATF judge.
All right, it will be extended. However, if you complete everything, then of course, you can ask for early termination. You understand?
Yes, sir.
All right, so this is what I'm gonna do. I'm gonna extend you for 2 years. Alternate amend conditions to do a referral to felony drug court. And if felony drug court doesn't accept him, then it will be SATA.
That'd be great.
Felony drug court will be able to probably interview. Next week is a short week, but they may be able to get to you next week. And you need to be honest with them about your issues.
Yes, Your Honor.
All right. Probation, we'll do felony drug court first.
Yes, Judge, and then SATF is not accepted.
Yes, and that's to be while in custody.
Yes.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
All right, we can go off the record. How old are you?
I'm 31.
All right, do you want to be the 31-year-old at the prison where somebody asks you why you're here and you say it's for marijuana? All right, do better.
Thank you.
All right, good luck to you.
Thank you, Judge.
Thank you.
Judge may be excused.
Yes. Who's here on Alberto Camacho? All right. Griselda Rosales?
Judge, I'm present for, she's here. Do you want her to come forward?
Yes.
Mr. Rosales, please come forward. Judge, I think I'm the agent of illness. She's feeling a little under the weather, so she's going to stand back a little.
Sure. All right, today is the plea deadline date?
Okay.
Yes. So is she accepting the offer or no?
No, Your Honor.
All right, Ms. Ferguson, we need a jury trial date on this and quick turnaround.
Could I ask for the same date I'm coming back on the other one, February 6th?
Sure. Norma, can you put this on February 6th for jury trial? All right, once you sign the reset form, you're excused. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you.
Judge, on the other case, Mr. Estrada, he really, really doesn't like me, which is why I didn't want to do the discovery, told me to stop.
Mhm.
I'm just telling you because I don't want to surprise you. I'm going to file motions to withdraw to protect myself.
Oh, I understand.
Okay.
Where is he? If you can come forward, sir.
And Robert Maurer threw his son under the bus and said that I asked him to take the case and he said no, but my son will.
Nobody can do as good as Eddie, Judge. He's the best judge I've ever seen. That's what I've ever seen.
His vision is
I would
also,
want him as my lawyer
Yeah,
if I were.
he has cataracts, so let's not.
All right, so I want to let you know something. You came before the court and you said that you had not seen the state's file. I'm being told that you no longer want to see the state's file. So let me just tell you what's going to end up happening. You're going to go to trial whether you've seen the evidence or not. That's completely up to you. The court gave you the opportunity to sit in court and look at the state's file. You're choosing not to. So you're going to come back for trial on that day. Do you understand?
It's not that I don't want to see it, Your Honor. It's just I've been incarcerated going on 3 years, and I just feel like I'm being rushed into something that.
Oh, no, you said you've been incarcerated for 3 years.
Yes,
So how
I
are you
have.
being rushed? You're going to
Exactly.
jury trial on February 6th.
And I'm barely hearing anything about it just within these past couple months, man.
He was
No.
in another county, Judge.
I've been in another county, so this whole time I've been incarcerated, I haven't heard anything out of Bear
So let me
County.
ask you this. I want you to internalize what I'm saying. You were in custody in another county for what reason?
For ag robbery, allegedly.
So there you go. So this case is going to trial on February 6th. If you would like, I've given you the opportunity to sit in the box and read what the state has. What the state has in their file is what they have. The only,
I understand that, Your Honor.
here's the thing, the only thing about it, what's in the state's file are the names and police reports. Those people are not going to come in and let you talk to them right now because
No,
that's
I-
not what
I
it is.
understand. I understand what you're
But
saying.
you can look at the file. So you're coming back for jury trial on February 6th.
That's fine, yes, ma'am.
All right, thank you.
Thank you.
Thank you, Judge.
All right, are you ready on Arturo Lopez, Alberto Camacho, Richard Alvarez?
I believe Alberto Camacho's attorney is in another court, Judge.
All right. So they are not ready. All right. Family violence.
Yes, Your Honor.
On Mr. Richard Alvarez, defense counsel is ill. So I'm going to grant their motion for continuance. If there's no objection, they have a doctor's note.
There is no objection, Your Honor.
All right, Ms. Ferguson, when do you want to recall Richard Almaraz? All right, so we'll do it on the 22nd then.
Thank you, Your Honor.
Thank you.
He's here, so I gotta give him the reset.
All right. Your attorney is out ill. So we'll bring you back on the 22nd. All right, just wait. And once you sign the reset form, you're excused.
Your Honor, may I quickly approach on the?
Yes. You're welcome. Hmm? They left you alone. But they brought in breakfast tacos.
That's true. All right, that's all fair. Thank you.
Sure.
Judge, you're not panicking, thinking Alabama might steal away your precious Brian Kelly?
No, I'm not.
I'm sorry, I didn't lay on the sarcasm enough. I didn't.
We're doing prayers. Sure. Yes, we'll take.
They had a vigil by the Nick Saban statue and they just kept chanting, anyone but Dabo, anyone but Dabo.
Alexander Torres.
Good morning, Judge.
Good morning.
A couple of things. Alexander Torres, they didn't bring him because he's got lice. But in addition to that, I filed a competency eval.
Okay.
And it was ordered back in November. So we're waiting for the results.
The report's ready, Judge. We're just waiting, I guess, for them to transcribe whatever they need to do.
All right. And how long is it going to take for the lice infestation? Okay, and then you immediately start scratching your head. All right, if you can.
He is incompetent.
Okay.
Yeah.
Norma, let's recall this in 3 weeks.
Okay.
All right, what date?
I can do February 8th.
You know what? Do it the following week. I'm sorry. Yes, February 15th. Is that okay with you, counsel?
Yes, Judge, that's perfect.
All right.
Okay.
I see the vacation photos.
But I've been back and it's. But I'm.
It seems like it.
Yeah. Thank you, Judge. I still have one other case.
All right, sure. And Norma, I need the files on Pete Garcia that have been dismissed.
That's the most important.
Arturo Lopez. Where's the attorney? Just have a seat. We'll wait for your attorney. All right, everyone, as soon as the court reporter comes up, we'll take up Mark Hernandez. Is that you?
Yeah, the state didn't have any objection. We just wanted to approach. I don't necessarily need a record if you don't.
All right. What is happening with his case?
Well, Judge, the probation thought there were some positive UAs for alcohol, but he's diabetic and they have proof of that, which would cause the false readings for alcohol. So he's completed everything. My understanding, the state didn't have any objection to the early termination.
All right, so he's not here.
No, he's present right here, Judge.
All right, why would he show up late?
Judge, I can tell you he texted me and asked if he should wait in the hallway at 9:15. So that may explain it.
All right, because we start at 9.
Judge, when I get to this court, I like to be here at 7 o'clock.
See, if you would have told me 8:30, I would have said, maybe he's here.
Overplayed my hand.
You did. So what is probation on Mark Hernandez?
So, Judge, I know that we spoke last week and at the time we were opposed for his early termination. Since then, and that was mainly because we were expecting a violation report and a motion to revoke to be presented to the court for alcohol use. However, since then, we have received medical documentation that Mr. Hernandez has diabetes. And so it's going to come up positive for the glucose on the alcohol. He has completed his intensive outpatient treatment. He's up to date with his fees. Everything else is going rather well. I did speak with the manager and I spoke with the the supervising officer, and they have no opposition at this point for early termination.
All right, and the state has no opposition?
No.
That is correct.
All right, so let's do this. I want a UA.
It'll come back positive for alcohol.
Well, it shouldn't, no, because they don't test for alcohol here.
Okay,
So I want a UA.
okay.
And if that UA is negative, then I will proceed how I will proceed.
Okay.
Mr. Hernandez, what are going to be the results of, come forward, what are the results of this UA going to be that you're going to take today?
They should be negative for everything.
All right, so we'll do a UA. Are you prepared to go now?
Yes.
All right,
Judge, I'm gonna run to the trainer. I'll be back in a couple minutes.
sure. Alberto Camacho. The attorney for Alberto Camacho.
Judge, that attorney is still in another court.
All right, the attorney for Arturo Lopez.
I think he's, I believe that'll be a plea, Judge. I think that's, yes, ma'am, that'll be a plea. Mr. Cantrell stopped by, so I'm gonna get that paperwork right for him, but he's still.
Okay. All right, once they're not ready on either of these.
Mr. Mitchell,
Mitchell?
Jonathan Mitchell. Well, just like I'm sorry, we need the application and the certificate of probation. Is he applying for probation? We need the probation paperwork and the certificate. Thank you.
Jeremy Duke. Oh, Norma. If you call back Teresa Garcia, because she also has,
Yes, she's
okay. Jason Wilson. Good morning. Oh, no, he's here.
Yes.
Are you all ready? All right, you're on this side. I don't know why you keep coming to the middle. You're on this side or either that side. All right, could I see the file on Jason Wilson, please? Have you conferred with the state?
I have, Your Honor.
All right, this is criminal trial division. And is this a motion to modify?
It is, Your Honor. It's also an occupation, a request for an occupational license.
All right, so the court doesn't have any of those motions. So as soon as they're pulled, we'll take it up. If you'll have a seat. Caleb Crum. Good morning.
Zach and I have been conferring on this one. This is the one where there was confusion about mental health providers. I've spoken with Kelly Bernstein. She is willing to do the evaluation that I was wanting, which is for purposes of maybe some guilt and innocence, but mostly for punishment if it becomes necessary. In our discussions last time, it became apparent that You thought I was originally seeking competency, but when we talked further, we agreed that maybe it was a good thing to be done. Hate to say it, I thought I'd put these in, but I guess they got lost in the holiday shuffle. My kids had some health issues, my parents had some health issues, it just is what it is.
Okay.
Since then, Mr. Crum has been arrested on 3 new misdemeanors, on the same day, but
Yes.
3 new misdemeanors all the same. And you've revoked his bond. I don't have a motion to set bond in front of you. I don't know if you need one or if you can do it on B page, but Zach and I have agreed from 30. 20 was. the
No, your
original.
client will need to be here.
Understood, okay.
Okay.
I was hoping to get the bondsman prepared with the money ahead of time. But.
Yeah, he'll need to be
understood.
here.
All right.
So,
Could you tell me if you're inclined to grant that amount?
I mean, I don't know until I hear
Understood.
things. All right, so are you going to have your own mental health expert, or are you gonna go through the county?
So I was thinking both. Mine wasn't going to be looking at competency necessarily, but how his brain works when it comes to reacting to stimulus around it based on his prior diagnoses, for purposes of A, mens rea for guilt and innocence potentially, and then B, for if he is convicted as a mitigation expert at the sentencing range.
Okay, so in order to approve this,
I have.
I mean, do you have an idea?
Yes, Judge. Okay. So I have the 2 orders. Sorry, I thought I'd put them up there.
No, I have this motion.
You asked me prior to this to bring an updated order for competency and
Yes.
this, so that's what I have here in my hands for
Okay.
what's worth. On the Bernstein, I'll pull up an email that has her rates. I was gonna be asking for about 700 to start on Miss Bernstein. That would
Okay.
allow her to go over medical records and have about 2 to 3 sessions with him to get an idea. And then my goal at that point was if I felt it was going to be important for trial purposes, I would come back and ask for additional funding at that time.
Okay.
We'll bond it in. Do you want him to do that? Yeah, that makes sense.
And you still want the competency eval, correct?
Yes, Judge, just because if we were to private pay for that, the amount of time that she'd have to spend, I'd have to ask for more. So if there's a built-in mechanism within the county and he qualifies, which I think you're in agreement that he does, then probably makes most sense financially for the county to have someone who's already on the payroll, so to say, do that.
All right. Ms. Ferguson? On this case, it's not on the docket, but the competency request has been signed. So you can make sure that doesn't get lost in the shuffle. And then if you want a copy of the order that the court has just signed, you can have that.
Perfect. And you did 700, Judge, or?
Yes.
Okay, perfect. Thank
Ms.
you.
Ferguson, this and this belongs in the file too.
My excuse.
Yes, if you want to make a copy of that, you can.
I will. Thank you, Judge.
All right.
Have a great weekend.
You too. Teresa, who do you have?
Judge, I have Jesus Nato Trevino.
All right, Jesus Trevino.
Judge, I was appointed to this case in December. And I didn't have any locating information. He was out on bond.
Okay.
And this is the first time I'm able to have a conversation with him. And I will be filing a competency eval.
Okay.
He has this case, and then he's got a night mag case, Judge.
All right.
That way, it's a process.
All right, Ms. Garcia.
Okay, but I might understand that.
We're going to recall this back on February 15th as well to make sure we are where we need to be.
Okay, Judge, and yeah, Trevino. And Judge, do I file it directly through e-file?
Yes. Ms. Ferguson. On Jesus Trevino, that's going to be a request for a competency evaluation.
Yes, ma'am.
And so we're going to recall it back with her other client on February 15th, just to make sure everything is in order and he doesn't get lost. And that's Jesus Nato Trevino. That's on page 6.
Yes, thank you, Judge. May I be excused?
Once he signs the reset form, you have a question, sir?
No, I just wanted to let you know a little about my character. Even though I have some record, and something from the past when I was young and dumb, I'm not a bad person. I do work, and so I'm getting back on my feet. I'm having this little problem of identity theft that keeps on getting in the way of people stealing my identity and using it, and so. But I won't let that stop me. I'll still continue to get back on my feet, work. And so I do have a job that I just started.
All right, Mr. Trevino, I want to let you know that when people come before me, I don't see people as criminals or anything of that nature. I see people as individuals. So your past is your past. And sometimes past has to be considered. But I view cases with an open mind.
Correct. Just to let you know that here in court, I will tell you the truth. No lies at all, because I want the truth to come out to the table.
I appreciate that. Thank you so much.
Thank you, Judge.
All right, once you sign the reset form, you're excused. All right, is the party here on Nicholas Aguilar?
Yes, Judge, we're here.
Good morning. How are you doing?
Great, how are you?
Oh, I cannot complain. It's a beautiful day outside.
It is a really nice day.
I'm
outside.
currently alive. I mean, you got to be happy about that.
Absolutely. Good morning, Your Honor.
Good morning. All right, so today an offer was due.
Yes, sir. We gave it off.
Okay,
At this time, my client is not inclined to accept it.
all right, Ms. Ferguson, can we recall this in 3 weeks? That will be your plea deadline date. After that time, if you choose not to accept the state's offer and an agreement is not reached, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court and you'll be headed for jury trial. All right, what date, Ms. Ferguson?
February 6th.
All right, we're coming back on February 6th. That's that's your plea deadline date.
Thank you, Your Honor.
Have a seat, sign a reset.
And if the state is ready and they want a jury trial on that day, you may be able to go to jury trial on that day.
I don't want to go to jury trial ever for the rest of my life. I'm always. They take it out of me.
Are y'all ready on Tony Torres?
Ready.
Okay.
Defense is ready. Did we approach?
Yes. State, are you ready?
Yes.
Come on. I mean, you can resend Nicholas Trevino.
All right, court is calling 2023 CR 10354, State of Texas versus Tony Torres. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Jonathan Michelle for the defendant. We're ready.
are you Mr. Torres? Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Torres, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are good.
Mr. Torres, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it? Excuse me.
Yes, ma'am.
There's somebody coming up behind you. All right, did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do. Just for the record, Judge, my client's made me aware that he has a learning disability, that he is bipolar. I've spent plenty of time with him. He understands what a jury trial is. He understands that he has the right to go to trial. He understands they're offering probation, and he understands what's going to happen if he doesn't follow the rules. So I joined him in his waiver, asking the court to accept the plea agreement.
All right. And do you believe he was sane at the time of the offense?
Yes, Judge.
Mr. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am, 100%.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishments to be assessed at 4 years in the prison. There's a $500 fine. State recommends community supervision. There's to be ignition interlock for half the term, DWI intervention, VIP, and the 2-year driver's license suspension. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge. He's on home monitor right now. He is not driving. He's not driving the vehicle.
State?
Yes, sir.
All right. Do both parties understand if he presents the court with an affidavit of non-driving and an affidavit of non-ownership of a vehicle, and there's no vehicle that he has access to, then the court will order scram or some sort of mobile device and not the ignition interlock. Does everyone understand?
We understand that, Judge. We've already turned that into you.
All right. So I know your plea bargain agreement stated for ignition interlock half the term, but are you okay or in agreement with there being a monitoring device, a mobile monitoring device?
Yes, Judge, that's just so that we can kind of make sure that we go with the fact or the assumption that they may have a car, and then we can go from there.
All right. Going to show you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counsel, have there been any such motions?
None from.
I keep looking this way. Showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 120 hours of community service restitution, and 10 days house arrest in lieu of 10 days in the Bear County Jail. Did you understand
Yes,
that
ma'am.
those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I do.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Good too.
State any evidence?
It all proceeds as if it's one of all attachments.
No objection.
All right. And state, are you going to have any objections to the 10 days house arrest?
No, you're.
All right, thank you. You may continue to confer. Mr. Torres, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney?
Yes, ma'am.
Did you understand it and did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Your Honor, we're asking to accept the plea agreement. He's done probation before and he's assured me he can follow the rules again.
All right, are you employed?
Oh, no, Social Security.
Okay, and what is the SSI for?
That was for learning disability.
Okay. Do you live with anyone?
Well, I have my own place, but I stay with my mom really because I live by myself.
Do you have any children?
Yes,
What are their ages?
16, 14, and 4.
All right, and do you have contact with them?
Yes,
How often?
all the time.
All
All the
right.
time.
All right, and what is up with the tattoo?
Which is, well, it's my daughter. Her feet,
Her what?
her feet, date of birth, her name.
All right, this is what the court is going to do. Court is going to sentence you to 4 years in the prison. The court, of course, is finding you guilty. Suspended and probated for 4 years. There's a $500 fine to be probated. Ignition interlock for half the term. If he provides proof, and I see in the report that he's provided proof of non-driving. Once he provides proof of non-driving to probation and also non-ownership or non-access to a vehicle, then the court will let him remain on the monitoring device that he's currently on. And that will be for half the term. There's to be regular reporting by Zoom or in person. Regular random UAs. $120 of community service restitution. If he would like, he can donate those hours at $7.25 per hour. I always tell people the food bank because there's always a shortage. But if there is some other charity you would like to donate to, you're more than welcome to donate to that, but not the human fund.
No, I've done it. I've done it to food bank.
You know what that is, right? All right. There is to be, since you don't work, it's going to be full house arrest for 10 days in lieu of 10 days at the Bexar County Jail. And that's due to, now there's a lice infestation there. That's due to that and because of the uptick in COVID. So on that full house arrest, you're in your home for the 10 full days. You're not allowed to leave that home for 10 days. You understand?
Yes, ma'am. It can't be at my mom.
Hmm?
It can't be at my mom's.
I mean, if your mother wants you to live with her, then it's 10 full days at your mom's house. But once you go, you can't leave.
Yes, I'll be there.
All right. There is to be proof of employment or SSI within 30 days. No employment as a home healthcare provider or with minors. There is to be 2 years driver's license suspension, DWI intervention, VIP live, DWI education, a referral to felony drug court, TAP evaluation out of custody, and probation will follow TAP evaluation recommendations. If they request inpatient treatment, we'll start with intensive outpatient treatment. So either way, we'll start with intensive outpatient treatment if he's not accepted into felony drug court. And there's going to be 90 sober meetings in 90 days. Probation, is there anything else he needs? Yes, please. And if he completes parenting classes, He can use those in exchange for the community service hours, or either he can pay off community service hours. So you can either pay it off, but if you complete parenting classes, then the court will consider those hours satisfied. Oh, thank you. Field visit or more application. All right, is there anything else you need from the court to be successful?
No.
All right, I'm sure you what's entitled Trial Court Certification of Dependents. Right to appeal. Did you review it with me? Did you understand it? And did you sign it? Because this is a agreement, because I'm eligible, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I'm hoping you're going to be successful at this. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. You understand?
Yes, ma'am.
And let me just tell you this, when people drink alcohol, nobody ever expects to get intoxicated and kill somebody.
Yeah.
But sometimes that happens. Don't be that person who goes out, drinks, and you end up killing somebody. No alcohol for you, and you're not allowed to have alcohol, period, while on probation. You're not allowed to smoke marijuana. You can't have alcohol in your home at all. While you're... All right, good luck.
That's all I have in your document.
All right, thank you. Thank you so much. Tracy Valdez. And this is an application probation. Court is calling 2023 CR 11178, State of Texas versus Tracy Marie Valdez. Could I have parties announced for the record for the state? Defense?
Bridget Gassa for defense.
Are you Miss Valdez? Court will. Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery? Did you review that with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Ms. Valdez, I'm showing you what's entitled Application for Community Supervision. Did you review it with your attorney? Did you understand it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you weigh the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1 less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Okay.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishments be assessed at 2 years in the state jail facility, $500 fine. State recommends community supervision. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation and community service restitution hours. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. I offer State's Exhibit 1 in the attachments.
We have no objections.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes. Your Honor, we're asking the court to follow the recommendation of the ADA. Ms. Valdez is 38 years old. She is homeless and she will continue to be homeless. She plans to reside at the Haven for Hope. While in custody, she has taken it upon herself to take courses in the reentry classes to reenter society. She's taken anger management courses. She's taken AA meetings at the jail. She's taken social classes there at the jail. She has been in custody for 127 days. So she is willing to comply with any conditions that the court may impose upon her. So she's asking the court to follow the recommendations.
All right. Do you have any children?
No.
All right. Do you have any family support system here in Bexar County?
Yes, I do.
And who would that be?
My aunt.
Oh, good. And what about mother, father?
Yes.
I'm sorry to hear that. All right. When's the last time you had employment?
It's been a while. I have,
How long?
it's been, ever since I've been, my mom passed away, like 2 years. 3 years.
All right. So you're going to have to get employment. Do you understand?
Yes, sir.
All right. So have you talking to somebody or had therapy to address the issue?
Yeah, I talked to the people from the reentry.
Okay. All right. This is what the court is going to do. The court is going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There will be 100 hours of community service restitution. She's to reside at Haven for Hope. Of course, if you're able to get housing, just let probation know.
Yes, sir.
I'm going to run a referral to felony drug court. If felony drug court accepts you, and they will, if you're honest with them about your drug use, and they will help you with housing, they'll help you with employment, they'll help you with any trauma or therapy you need in regards to your family. You understand? There is to be regular reporting by Zoom or in person, regular random UAs, a TAP evaluation. I'm going to want a MIC evaluation. Felony drug court, that's going to be done while she's in custody. They should be able to see her. Next week is a short week. So no later than 2 weeks, they'll be able to evaluate her and see if she's eligible for their program. I'm going to want field visits 1 time per month for 4 months. And then thereafter at probation's discretion. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. I'm going to want the TAP evaluation, MIC evaluation, and felony drug court evaluation in custody. Of course, if felony drug court accepts you right away, they'll probably remove you from custody and the MIC evaluation and TAP will be done out of custody. Probation, is there anything else she needs?
No, Your Honor.
All right, is there anything else you need from the court? All right, and I'll do no unsupervised contact with minors. All right, I'm gonna show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, good luck to you. We're off the record. If you need anything, let probation know. If you feel like they're not addressing it, you can always come back to court. All right? Thank you. Who is here with the interpreter? All right, let's take your matter up. Who's your client?
Mr. Royal, we have two witnesses.
All right, so this, we're gonna have to, Norma, we're gonna have to bring this back at 1:30. Counsel, we're gonna have to bring you back at 1:30? Yes, because I have to go visit the juvenile detention center. Jasmine Hunt. All right, are there any witnesses on Miss Hunt?
No, Your Honor, it's just a procedural matter right now, just
Oh, sure, come forward.
kind of a status matter for.
Sure. Yes, what is the procedural matter?
Speaking with probation Your Honor, on, we were trying to get her into mental health court, Your Honor, on this, on a CPD. I understand she's up for another evaluation or meeting this coming Tuesday, Your Honor.
Okay.
So we wanted to keep it, I wanted to keep it kind of close tabs on it because she's been in jail for so long.
Okay,
So we were thinking about maybe next Friday or so, recall it.
all right, let me see. Norma, are we able to recall this on Thursday, the 18th? All right. Probation on Jasmine Hunt, it's going to be recalled on the 18th. Counsel said that there are some other evaluations.
Yes, sir.
Okay. All right, Ms. Hunt, we'll see you back on the 18th, okay? All right, everyone, I am sorry. I know that you all have cases that are pending, but I'm supposed to view the juvenile detention center. So that's something I have to do. So we're going to come back at 1:30. And so the people coming back at 1:30 will be Devin